one of the questions we get asked a lot is, what's the process of the court-martial system? Is it different than state court? And at what point in time do we think about taking a pretrial agreement? At what point in time do we talk about going to trial? To do that, I really need to explain, or just try to do over the air, how the court-martial system works. Just step 1, step 2, step 3. Oftentimes in step 1, our clients are under investigation. They're under criminal investigation. Many times they call us, they'll have us represent them. And this is when we try to get their side of the story unearthed. Maybe not put out, but unearthed. And by that I mean CID, NCIS, FBI, anyone's investigating them, they already believe that they're guilty. So people bring us on board, so we use our own investigators, we use our own defense team, we put things out there to try to get their story told or to get their story documented, because I can't tell you how many times that as soon as NCIS gets involved, all of a sudden the exculpatory witnesses run away, they have memory losses, cell phones with exculpatory information get erased, or all sorts of things happen, or they get duped into taking these BS polygraphs. These things happen all the time when we're not involved. So this first part of the process is where a client is under criminal investigation is maybe one of the most important times to bring in an attorney, because oftentimes we can derail the train. We can stop things before they start, or even perhaps keep you from getting charged. And that's step 1. Step 2 is, if we're not successful in doing that, or you bring us on too late, or you're just going to get charged, it's called the preferral of charges. The preferral of charges is similar to an indictment. That's when the command through the JAG office says, we're actually charging you. A military service member gets called in, they're usually scared out of their mind, they don't know what's going on, they get called into the commander's office and they're read a charge sheet. Now, you know you're officially charged if it has your name, your social security number, your rank, your information on the very top. It says charge sheet, and it says on or about, let's make up a time, July 31st, 2016, at or near Schofield Barracks, Hawaii, you, PFC, Jonathan Smith, did X, whatever that thing is, fraud, sexual assault. Once you receive that, welcome to the club you never wanted to join. That is being charged in the military. Now, the military has about 1.4 million service members in it last time I checked. That's active duty, non-active duty. That's 1.4 million service members. Now, the report by Congress put out that there are about 7,000 sexual assault allegations that are made. So the number is relatively small in part of, in the context of the overall military, at least for sexual assault, but that's a club you don't want to be in. It's a club you absolutely don't want to be in. And whether it's sexual assault or fraud or anything else, you are now officially charged. The next step is called the Article 32. Now, the Article 32 is a preliminary hearing in the military where an independent, and I put independent in air quotes, if you're watching us live on the air, or if you are watching me on YouTube, it is an independent investigating officer who is also a JAG, who is going to, quote, investigate these matters or look at the matters. Maybe it's a preliminary hearing officer now. It used to be an investigating officer. They're going to look at the evidence and determine whether there's probable cause to go forward. And in days past, meaning years ago, when things were done correctly and right, in my opinion, the defense used to be able to put in evidence, be able to call witnesses, put in evidence to show that there wasn't probable cause in the case should not go forward, and we'd have a real honest hearing. A hearing officer, we're going to have an honest hearing. But the rules changed because Congress, in all of their wisdom, many of you know my thoughts on Congress, have changed the rules, so there's not really a hearing anymore. What it is the government puts in a paper evidence, they put in the evidence that NCIS or CID collected, and they argue that there's probable cause and they don't call any witnesses. If it's a sex assault case, the victim doesn't even have to testify. How you like that? Doesn't have to testify. Now, as an accused, you can call people to testify at the hearing, but you have to ask the government's permission to do so. Isn't that interesting, the way that works? You ask their permission to call these witnesses, and routinely they're denied. Denied, is relevant, is not relevant, as cumulative. If there's any statement anywhere in any packet that exists, their testimony is going to be cumulative. It's an absolute joke, and these hearings have become what is known as a rubber stamp. And so oftentimes the decision is made, do we waive the hearings? Do we go forward with the hearings? And clients, we got to do the 32. We got to do the 32. I hired you. Please, God, we got to do the 32. And I tell these clients that this is garbage and it's a rubber stamp. That almost every case where we don't believe there's probable cause, where we believe someone's been falsely accused, they go forward anyways, even if there's evidence that they're innocent. The last case I had in Germany, this issue happened. An Article 32 officer actually recommended it didn't go forward. Can you believe that? I'm mind blown. Command at the JAG office, we're going to go forward anyways and take it to trial. So they took it to trial, and it was almost 9 months later, and we got an acquittal in 47 minutes. So you probably should have listened. How often does it happen where there's a recommendation to not go forward on a case, where they go forward anyways? And I'm focusing in on sexual assault cases. Every single time I get a recommendation, it doesn't go forward. So I started doing some digging, and I've got my laptop here because there is a subcommittee report that was put out last year. And this had a part called Data on Article 32 Recommendations and Convening Authority Referral Decisions. And I'm going to read this exactly because I thought, when I read this, my mind was just blown, and maybe it's just me because I'm passionate about this. But going to these Article 32s, it says the services provided case information and documents showing that out of 416 sexual assault cases that went to a general court-martial in 2015, these are 2015 numbers. So of the 416 sexual assault cases that went to a court-martial, 54 cases involved an Article 32 investigating officer or preliminary hearing officer recommending against referral of one or more of the sexual offenses to court-martial. So it's on 2 pages here, of the 54 cases that went to trial, of the 416 cases that went to trial, 54 of those, the Article 32 officer recommended don't go to trial, don't go forward. So you would think of those 54, those would not likely go to trial. Now, here's the number. Of those 54, how many do you think went to trial? Al, I'm going to push this over to you. Of the 54 where there was a recommendation to not go to trial, and this is an Article 32, a hearing officer said, there's not enough evidence to go to trial in 54 cases of sexual assault. Of those 54, how many do you think were stopped at the Article 32?
About half of them?
None of them.
None of them.
Not a single one. The committee report says in all, let's see, let me read this directly. It's on 2 pages again. 54 cases involved an Article 32 investigating officer or preliminary hearing officer recommending against referral of one or more sexual offense charges to court-martial, and the convening authority elected to refer the charges to a general court-martial despite that recommendation. There were 54 times in 2015, 54 where the convening authority referred charges to a court-martial when there was a recommendation not to do so. In all of those cases, in every single one of them, the staff judge advocate's pretrial advice to the convening authority was to refer the cases to a general court-martial. So in every single Article 32, so members, if you're listening saying, should we do the 32, should we waive it, we've got to do it, let this sink in. 54 times in 2015, there was a recommendation not to go to trial. Of the 54, all 54, the staff judge advocate's advice to the convening authority was to send it to trial anyways. What the hell? Send it to trial, let the system work out. Now, these numbers just get more and more interesting and perhaps sad. Of the 45 of the 54 cases, so 45 of those, Alf, full acquittal. Acquittal. So, of the 54 cases where they said it shouldn't go to trial, the JAG said, we'll send it anyways, 45 of them were a full acquittal. So that's 45 cases where innocent people went to trial, innocent people had to stand trial, had to go through hell and back, had to go before a jury, had to spend all this time, money, effort to get back to where they were probably 6-8 months ago. 54 people. But the sad part is that of the 45, I should say, 9 were convicted. 9 were convicted. Now, if you want to talk about false convictions in the military, wrongful convictions, let's start with this number. So what this number tells me is that in 54 cases, probable cause did not exist by an independent hearing officer. 9 of those cases, that individual was convicted beyond a reasonable doubt. So how can you, in one instance, have an individual who's a JAG say no probable cause, and that's the low standard, but a jury say beyond a reasonable doubt? My take is that's probably 9 wrongful convictions. That's in 2015, the numbers have only been going up. So if you don't think wrongful convictions happen, if you don't think there are innocent men in prison right now in the Briggs, go talk to these 9. The same 9 who the convening authority said, we're going to send it forward anyways, even though an independent officer said there was no probable cause. These numbers were just shocking to me. I always believed them to be true. I read them in a congressional report and my mind was just blown by this. So what's the purpose of a 32? The purpose is to grab your stamp, grab the ink, stamp it, stamp it, stamp it, stamp it, stamp it, stamp it. It doesn't matter what you bring forward. And how sad is this? How sad is this? So people say, why are we waiving the 32? Because we're not going to get anywhere anyways. And they may add additional charges against you. There is a rare case where I think, in my own opinion, it's worth doing the Article 32. Because it doesn't matter what's going to happen, unless things have changed since 2015, but my take is in 2016 this happened, 2017 this happened, and this year this has happened to me. And I do this date, I talk with my associate Dave, I talk with other attorneys. I can't find a one where this hasn't been the case. So that's the Article 32 process. And it's broken. It's absolutely broken, and the recommendation from this report was to fix it. It's absolutely broken. So if it gets past the Article 32, by the way, which it will, because of the 54 in 2015 that shouldn't have made it past the Article 32, they all did, then you get to what's called the referral of charges. That's where the convening authority comes forward. The referral of charges is where the convening authority reviews all of the pretrial advice, they review the evidence they're supposed to, and they make a decision to send the case forward to trial. Once that happens, it's essentially out of the command's hands, so to speak, and it's into the courts. From there, you have an arraignment. We go through the arraignment process. That's where you need to tell the court who your lawyer is going, who the judge, who your lawyer is going to be. So if you're going to hire civilian counsel, you really should have it by arraignment, because then we work on scheduling, a pretrial order, motions hearings, and we set the trial date. The next phase, we go into motions hearing where we litigate any and all issues that there are, suppression issues, witness issues. And on witnesses, they'll deny all your witnesses, members. If you're accused and you've got witnesses that you need, you've got to go, Mother, may I please have a witness that I need to have a fair trial. You got to ask the government for this. And then they deny them. You need an expert? They have, let's say there's DNA in your case and there's DNA that's exculpatory. Government's going to get an expert from UCMJ. The U.S. Army Criminal Investigative Laboratory. You need an expert to show that the DNA is exculpatory. What do you have to do? Convening authority, please, can I have an expert? Can you throw me some change? It's like a beggar on the street. Can you spare some change? Spare some change for an expert so I can have a fair trial? And almost unilaterally, they say no. Then we got to go to the court, file a motion with the judge, beg the judge. And I don't beg anyone. But ask for these experts, and then the experts come, and then they don't want to fund them. And this is the exact issue that happened last week. The expert got to court, and they don't want to fund the expert. So it's this massive amount of gamesmanship that's played. And this is why motions are important. This is why all the pretrial litigation is important. And this is why if your lawyer doesn't know what the heck he's doing, or if this is his first, second, third, or fourth trial, when he hits roadblock after roadblock after roadblock, he doesn't know what to do. That's why he needs someone, God forbid, that knows what they're doing, because your life's on the line. It's your life. It's not mine. It's yours. And so if you're going through this process where everything's stacked against you, and if you don't believe me, you think that's some pitch, look at the numbers. I'm going to post this online on our Facebook. I'll post this. Look at the numbers. And then once we go through all of this, if the case still makes it to trial, oh, and by the way, going to my law partner's point, through the entire process, what's going to happen? These prosecutors are going to say, if you go ahead and plead now, we'll give you a good deal. If you make us do some work, the deal's going to get worse. Every time. If you make us do some work, well, it's your job. God forbid. Stop the press. God forbid you got to do some work on this, because you've charged someone with a crime that you think you can prove. God forbid you actually have to prove it. So why do they give you these deals early on? It's because oftentimes they can't prove the charges. Oftentimes you're overcharged. All of these things come up. So of course they want you to deal because they expect you to. So when they get an attorney who comes in there and fights and says, deal, do some work, giddy up, let's go. You get someone like me, and obviously, do you think I lay down easy? Do you really think prosecutors like dealing with me? I get Christmas cards, but they're not from prosecutors. Okay? So what I tell them in return is, the deal gets worse for you. We'll submit a deal right now, but if I've got to do some work, then the deal gets worse. I flip it on them. And they go, whatever, Mr. Bilecki, whatever. And this happens over and over and over. The deal gets better with time because the prosecutors realize their case is typically garbage. Then God forbid they have to get to court. You look at the prosecutor, oh, how many of these have you actually prosecuted? I've done 3, 2 were guilty pleas. I lost the other. Right? And so you get there, and the deals get better. That's why in day 2 of trial, day 3 of trial, all of a sudden the deals drop tremendously because the prosecutor realizes their case sucks and they're outmatched and outgunned. So deals do not get better with time. They do not get worse with time. They usually get better. I said that wrong. For the prosecutor. So once you go through all this, the final phase that we're really involved in is the trial itself. And that's when everything gets put together, all the prep work comes in, we're doing everything, we finally get it to trial. Now this is where experience matters. This is where execution matters, because there's this bridge. If you think about, I'm gonna date everyone except for maybe Alan, my law partner. Remember Roadrunner? The 𝗕𝗍 Coyote, and there'd always be two little mountains. Remember this big bridge across it that either the Coyote or the Roadrunner would have to cross this bridge. But if you think about, there's two big pillars, right, on one side, and there's no bridge, all right? On one side is all the prep work you've done to get to trial. On the other side is an acquittal, and there's this vast chasm in the middle. And over and over and over and over, lawyers who really don't know what they're doing think they're ready to cross the bridge. They're running, and it's just like the coyote, run. What happens? Ooh, boom. There's no bridge that's built. And the bridge is execution. It's experience. So we're able to build that bridge, and that bridge is built by knowing what you're doing, having the experience, having tried 100+ cases, knowing how to pick a jury, knowing how to cross-examine witnesses. It's done by knowing how to have feel in a case. And by feel is you're able to hear what a witness is saying and how that plays out in 3 or 4 witnesses ahead. How to have this strategy, and most importantly, how to talk to someone, how to talk to a jury, and have a compelling argument for them. And when you have all of these pieces, the experience, the know-how, the work effort, all of those things I just talked about, you start building a bridge. And what happens is, if you want to get from that side of preparation to the other side of a full acquittal, the land of the milk and honey, the promised land, you got to have a bridge to get there. And that bridge is having an experienced attorney who's actually tried cases and tried them and won them. So that's the steps of a court-martial. And so the takeaway is you can get to the promised land, but you can't get there on your own, and it is an incredibly difficult journey. We just retained a client, I think it was about a week and a half ago, and I had this conversation with him. He thought the minute he hired me, it'd be easy. Oh, we're good to go, sir. I said, no, the pain just starts now. It's only going to get worse before it gets better. And you got to understand, if you're criminally charged, whether it's here in state court and here in Hawaii, or in my world, the criminal world of the military, you're going to go through hell. But you can get to the other side. But everything's going to be stacked against you along the way. So it's important to understand the different phases and how to get there. And you have someone like myself who actually cares and knows what they're doing. And the prosecutor just is like mind blown when he does these opening arguments, these opening statements. If you want to see how it's done, go to the docket, call our office, find out when my law partner's in court or in trial. You want to see how a case is tried. You want to see advocacy. You want to see how cross-examination's done. Do 2 things. Go watch the free military lawyer do it. Take some notes. Then go watch my law partner or go watch me do it. And you decide. Because what you have in this world, the only thing you have left is choice. You can choose your destiny. You have the choice. You have the choice whether you want to cross the bridge. You have the choice of whether you want to end up in prison. You have all of the choices are yours. You didn't choose that you were charged, but you have the choice for how you're going to fight it. And if you don't make that choice, you're going to be a victim and not a victor. And I don't believe in being a victim. Life is short, life is fleeting. We only have a certain amount of time on this earth that God's given us, and we got to make the most of it. And in anyone's life, there are certain moments of your life that you remember, whether it's moments with your parents, moments on a family vacation. There are moments. I truly believe that this life is lived in moments. And it was 2 years ago today after the client retained us. And I know this because you and I are pretty big car fans, and we went to SEMA 2 years ago, and the client retained us while we were at the SEMA Auto Show on a little partner getaway for a couple days. So this was 2 years ago today, this client retained us. But going back to life being lived in moments, after the trial, 47-minute full acquittal. My client was out there. My client's from Guam. His name is Joey. Great kid. Great kid. His fiance and Joey, if you're not married yet, get your head together and marry this woman. She's amazing. And they have a little girl together. She was 4 years old, the same age as my middle son. After the trial, we hugged it out. We went outside, and I watched with my own eyes this little girl. She was this 4 years old girl, right? She's running up to her dad with this big smile on her face. Joey picked her up, held her up tight, and said, "Daddy's coming home." And I was like, mind blown. Because what I realized, I knew this all along, but I really realized that what we do is so much more important than a fee. It's so much more important than the advocacy. What we do, I say it all the time, it changes lives. Because there were two courses of action that could have happened outside that trial. His fiance, which I hope they're married now, and they were going to get married. Their life got put on hold, and the wedding got put on hold. Everything got put on hold for this trial. He'd be walking out in handcuffs, being taken off to the brig for a crime he did not commit, for a crime where the 32 officer said, don't go forward to trial. He'd be hauled away. His daughter's life would be changed. His fiance, now his wife's life, would be changed. His life would be changed. All of this in a moment. The moment you stand up and the jury says of all charges and specifications, like, you pause and your heart beats. And the minute it stops doing that, got to get out of this business. And they say not guilty, 2 years of hard work. And flashing back to when you and I were at the 𝗲𝗎𝗓 show and I talked to this client, when you and I talked about it, saying, should we take on this client? Because Noel and I, we discussed that. He said, this is a client with merit. This is a client we need to take on. 2 years later, all the fights, multiple trips to Germany, lots of money that he spent that he shouldn't have had to. His life changed in that moment. And I had a front row seat to it. I had a front row seat to that moment of his life where he said, Daddy's coming home. That was so impactful. That's what it means to be victorious. What being victorious doesn't mean is, ah ha ha, prosecutor, we won, because to them it's no, we are block, it's a game. To other lawyers, it's high five, oh yeah, move on to the next case. But to me, it means reuniting a family. To me, it means changing his family tree. To me, it means doing some good in this world because we're able to right a wrong. It means being able to, again, change someone's trajectory. And that's a hell of a lot more powerful than high fives and beers. I'm going to get a wedding invite. I want to go out to Guam. I want to go out to Guam. His fiance does cultural dancing out at one of the big resorts out in Guam, and they're going to put on. They better put on a big. They do luau's in Guam. If they do, if they don't, they should. And we should get an invite. The issue is not the issue, but the reality is that's just one case that's sticking out in my mind because it was recent. I mean, you have these. I have these. I mean, I can tell story after story. We should write a book. I can tell story after story after story about this. There was one an individual we represented at Fort Polk who was wrongfully accused. It was like a 17 or 19 minute verdict. It was crazy short. He got out, was able to retire, and now he's flying helicopters out in the Middle East doing great things, supporting service members. And so there are story after story after story that can be told, and you've got them. Al, you've got them. Anyone who tries cases and gives a damn has these stories. And not just having a front row seat to this moment in time, it's being the architect of it. And God, that's a powerful thing, right? Because you can be the architect of this amazing building and look back and say, wow, we built that. Or you can also be an architect for some piece of garbage that crumbles down and falls apart and the whole thing falls down and you don't want to have anything to do with that. And the reality is there's a lot more pieces of garbage that have fallen down than beautiful high rises out there, metaphorically speaking.